Hi, and welcome to part 2 of the podcast on liquidated damages. In part 1, I have explored the concepts of liquidated damages, delay damages, and liquidated and ascertained damages with Hamish. Hamish shared his experience working as a contractor FIDIC engineer, claims expert, and FIDIC adjudicator, giving valuable tips for contractors, employers, and delay experts regarding the liquidated damages mechanism. I will leave a link to part 1 in the description below. In part 2 of the podcast, we continue to discuss the UK Supreme Court that dealt with the LD's provision in a recent case, Triple Point Technology versus PTT, the meaning of the decision and what delay experts can take from it. Stay with us to find out much more on the subject of liquidated damages. Welcome to part 2. I hope you enjoy it. This liquidated damages mechanism works hand in hand with the extension of time, isn't it? Can you explain a little bit how they work together and why do you need both?
Well, whether the egg comes before the chicken in this one. Contracts will provide normally for an extension of time where there is a situation that justifies the award of further time for the contractor to complete his works. If the contractor prolongs the contract because of his own actions, then obviously an extension does not apply and the contractor suffers accordingly. Now, when an extension of time as such would deny, well, it's not very good to use the term deny, but an extension of time awarded by the employer obviously means the employer cannot seek delayed damages or liquidated damages for the prolongation of the contract. Therefore, liquidated damages in respect of extension of time, they're not consistent. You only get liquidated damages when there is no extension of time.
So that's why
Understand?
contractors seek extension of time to get relief from liquidated damages.
Exactly. They've got to justify that the prolongation of the contract was not of their making and was the responsibility of the employer, and thereby the employer cannot, by the prevention principle, the employer cannot claim liquidated damages. So it's not a matter that they go together, they're actually in opposition to each other. You mentioned when you contacted me, you referred to a recent decision, a judgment given in the UK Supreme Court on
Correct.
this matter of liquidated damages. It's Triple Point Technology Incorporated who were the respondent at the Supreme Court
Yep.
versus PTT, a public company limited. They were the appellant. This was in 2021, and it was under the UK Supreme Court number 29, 16th of July 2021. This was a case, an appeal from the English and Welsh Court of Appeal 2019, CIV 230. You gave me reference to two articles, one by Hamish Lal, an old friend, put that friend in inverted commas, and an article from White and Case.
Yep.
I looked at both of them and then went back into the case details and the judgment and reasoning issued by the Supreme Court. I think in order to give clarity to the issue, that remember was what Hamish Lal talked about, that the Supreme Court had given supreme clarity.
Yes.
Of the judgment, but I'll come back to that later. I think it's good to give some details of the case.
Sure. Yes, please.
A services contract, which was called CTRM contract, was executed on 8th of February 2013 between Triple Point Technology, we'll call that TPT, a company from the United States of America, specializing in the development and implementation of commodity trading software. And The other party was PTT, a Thai company specialising, amongst other things, in oil and gas. The two principal objectives of the contract were identified under two phases. Phase number one, TPT would replace PTT's existing software with supposedly better software prepared by TPT. The second phase would TPT would expand the software to accommodate the development of PTT's commodities trading business. Quite a simple business challenge, but obviously it had great complications. Payment was scheduled through the use of milestones, and the next to the main part of the document to the contract was a document entitled Terms of Reference, which contained a list of agreed functionality criteria. The first two stages of phase one were completed by the 19th of March 2014, but this had been a delay of 149 days. PTT terminated the contract a year later on the 23rd of March 2015 with phase two incomplete. Reading the documents, the reports, there appears to have been an issue with unpaid invoices. Now I ask you, where have we seen that before? Triple Point commenced proceedings in the Technology and Construction Court for England and Wales to recover outstanding sums and unpaid invoices. Not quite understandable. PTT counterclaimed, however, for damages and liquidated damages for delay under articles of the contract.
Yep.
The Jefford judge dismissed TPT's claims, holding that PTT were entitled to damages in the order of about 4.5 million US dollars under liquidated damages, uncapped, and the costs for procuring an alternative system, as well as wasted costs.
This was the first instance, right? The court of
that's the court first instance. Yeah, that's Technology and Construction Court in England. But also have to mention Wales because that's the jurisdiction, England and Wales. Very good court. I think it's some of the judgments that came out of the TCC are I can say, excellent. They solve a lot of problems. And it's recommended other jurisdictions should have similar courts set up that deal directly with that commercial nature of the work, of the claim of disputes. Anyway, TPT appealed to the Court of Appeal, and PTT, they cross-appealed against the findings that any damages were capped. The Court of Appeal, the three judges in the Court of Appeal, set aside the judge's award from the Court of First Instance, the judge's award of liquidated damages, and they had 3 points to raise, saying PTT was only entitled to liquidated damages for work which had been completed prior to termination of the contract. Secondly, all damages were subject to cap. That's the important issue. And thirdly, that the exception for negligence applied only to freestanding torts. Torts is the English term for what other jurisdictions would call delicts. That's like, well, we're both familiar with Romania, but it's also the term used in Scotland. Mm-hmm. And not to breaches of the contract obligation to exercise care. The employer appealed to the Supreme Court on all of these 3 issues. The court, which is made up of 5 judges, these judges come from the Supreme Court comprises judges from the 3 jurisdictions in the UK, that's Northern Ireland, Scotland, England, and Wales. 5 judges, which means that you can get a majority decision. However, the court unanimously allowed the appeal on issues 1, and dismissed it on issue 3. So we're left with issue 2, where there was a majority. And Lady Arden, who was within the majority, gave her reasoning for the judgment. I'll not get into detail. I've got it set in front of me, which was the actual what the summary of the judgment. If you look at the case records, it's very good. You'll find that you get the full judgment provided, but you'll also get 2 other reports. One is a summary, which is very, very good. I recommend people to always search for the summary. And there's also another record of facts and issues. But reading the summary, it's quite clear that what the 3 judges in the majority decided was that there was a departure from what was customary, and the appeal judge's ruling was inconsistent with commercial reality. Looking at myself, I see that the appeal court had departed from what was seen as normal customary practice. The Supreme Court has corrected it by going back to what would seem to be not just customary practice, but common sense. There is this aspect of negligence that was in the referrals, and the judgment was such that the rule that negligence was not to be spread across all of the aspects of the working of the contract, but had to be specific. There had to be a specific tort that could be shown that negligence was a matter included in that tort. And the court said there wasn't anything like that. So the aspect of negligence was on the side.
What is the supreme clarity brought by the Supreme Court? So if you want to wrap up.
Yeah. Well, that's Hamish Lal. He's using what's known as a transfer epithet. In English, that means where you take one word and you put it on to something else. One example they give is that the term "the farmer trod his weary way home," right? Where the term "weary" is attached to way, but it's actually the farmer who's weary.
Okay.
So what Hamish Lal did was he gave this the court has provided clarity, and because it's the
Supreme Court,
it's supreme clarity, which is quite apt. And I say it gets back to this aspect that all the court actually did was made that it was commonsensical, it was clear, and got back to what was normally accepted to be the understanding of the liquidated damages.
You are an adjudicator,
right?
FIDIC adjudicator. Is this decision from the Supreme Court is going to change anything in your decisions? Are you going to adopt
I believe the judgment is welcomed by those in the alternative dispute resolution field, as it eliminates some of the possible complications of liquidated damage application. However, it's possibly the case that the effects of the judgment have already been addressed by ADR practitioners in their handling of such dispute over the years. The Supreme Court judgment effectively confirmed what's been the orthodox practice. I think as I say, the decision does make clear what some of the problems that we get with liquidated damages. And we do get this problem, especially where there is delay in completion and then there is termination. In this case, at least, there was a completion. I suppose that the work under phase 1 of the contract was completed and agreed by the employer. who then continued the contract then continued for another year before termination was applied. But we get real complicated, a more complex situation arises where there's been no confirmation of completion of any of the works and termination is applied. And where there has been a delay, is normally the case with termination, where a contractor fails to complete in time and the job runs on and the employer thinks, I've got to bring a stop to this. So the employer terminates,
Yep.
and there is no confirmation of any completion of the work. So the question then is it liquidated damages or is it all unliquidated damages? And that obviously has not been addressed in the Supreme Court decision, because that wasn't the point of the case that was presented to them.
Is this relevant to a delay expert like myself or delay experts out there?
I think you've got to be familiar with it. You've got to, a lot of times you cannot just go into an examination of the program, the schedules and the contract and not appreciate what the consequences of the situation are. If you're going to be supporting the claim for an extension of time, then, as I said earlier, the extension of time cancels out the application of delay damages or liquidated damages. So you've got to be careful that when you make that determination that there is entitlement for an extension of time, you have to be aware of what the consequences of that are.
Yes.
And
yep.
bear in mind that lack of knowledge of the contract or of the law gives you no defence. There's one point that did come up when I was reading the White Case article that I must admit I wasn't fully aware of. They make reference to the FIRIC Green Book, the 2020 edition, where the Green Book is on what I call the short contract. And where they're saying that in that version, the contractors are required to prove any time-related costs in a claim based on prolongation of the contract. You know, that when you get contractors pursue extensions of time in order that they can follow through with a claim for the costs that come from that extension. And claims for what I call time-related costs can be quite onerous and quite difficult and complicated and lead to some severe arguments as such. Anyway, the Green Book has perhaps put in the thin edge of the wedge into this matter of time-related costs by saying the contractor may be obliged to prove time-related costs. And this whole business of time-related costs, I'm suggesting, could be a useful subject for further discussion.
I made some
Maybe
notes.
I need to get one of these teleprompters and have it up so you're looking at my face instead of looking at the side. Though this is my good side. You know?
I have a teleprompter. You should get one.
Right. I'm an adjudicator. I'm not a claims expert.
I made some notes. Is it correct or incorrect to say that liquidated damages is a penalty?
If liquidated damages were a penalty, then they wouldn't apply. The insertion of penalties into contracts is another complicated issue. I have written contracts where quite clearly penalties were inserted, but you can get away with penalties if you provide the other side of the balance, and that is where it's a penalty for delay in completion, you actually give a bonus for completing ahead of time, right? Which is only fair. If you're going to punish a contractor for being late, and it's just a simple penalty that has no real aspect to the loss that you're suffering, then you can only get away with that if you give the counter, and that's give them a bonus. I had a trial with that at one point, but it soon died a death after the first operation of it. But it can be done. I mean, I think that there are, it's accepted that penalties to some extent can be inserted in a contract if you counter it with the bonus. But liquidated damages as such, if it's a penalty, then it would not be accepted. And it can only be accepted as a penalty where I say it's an unconscionable amount. It's absolutely ridiculous what the employer is claiming as liquidated damages, or even if it's an amount that there's no way the employer could prove that level. That aspect of penalty, I believe, has been ruled out by the repeated operation of contracts with liquidated damages, levied at an acceptable level. That is never considered to be a penalty. It's a fair assessment of the damages that the employer would incur. I mean, I went back to the days when I started out and working in, I think it would have been maybe even the second edition of the Institution of Civil Engineers Conditions of Contract. Bear in mind that the FIRI up until 1999 had based their conditions of contract on the ICE, that's the Institution of Civil Engineers in the UK. It's based on the ICE conditions of contract. And back in those days, under the second edition, it was very rare for employers to charge liquidated damages, because there was this aspect saying you have to prove them.
You have to prove
and
them. Yeah.
Difficult. Yeah, if you're working for an employer who's engaged in infrastructure, it's very difficult to assess the actual loss. I mean, if a sewage network is delayed, how do you assess the cost of the missing pipes, missing pipework? The disadvantage to those people who need the sewerage, but even to a road. If a road is delayed and traffic is journey times are still at a higher level rather than the lower level that the new road would give them, it's very difficult to assess the cost.
Yeah.
And it's very useful. And I think contractors agree. They've never really challenged this aspect of ascertained damage.
Another aspect of the liquidated damages is that, as you said, they do not have to be proved. The parties agree in case the contract completion date is delayed, an amount is applied or calculated weekly, daily.
What you've got to remember about the UK Supreme Court is a court in the UK, therefore their judgments are particular to the three jurisdictions in the UK. But you will get people from outside the UK, primarily those in common law jurisdictions, who will make reference to these, just as the same as in the UK will make reference to judgments that are made outside of the UK within common law. But those of us who work in the civil code jurisdictions, case law is such that what the common law aspect, which sometimes is referred to as judge-made law rather than through legislation, that's very foreign to some. And therefore references to the Supreme Court judgment within a civil code country would be a matter for assistance rather than for any definite solution.
That's the case for Romania, for example.
Romania civil code. I mean, Singapore, where you are, I believe, is common law.
Common law.
It'll be based upon the old British system,
yes,
as would be across the causeway in Malaysia.
Our first interview. How was it?
Yeah, Yeah, well, okay, we departed a bit from the script,
A little bit.
and that
Just make it fun.
probably increased a bit of hesitancy.
Thank you for listening to part 2 of the first episode of my podcast series. This completed my first interview with James Dow on liquidated damages. You can find all this information on my blog at asultan.com. There you'll find in-depth articles, notes, and links to publications related to this episode. You can find me on LinkedIn and YouTube on social media if you want to share your questions and comments. I'll continue to invite professionals from the world of arbitration, dispute resolution, and delay analysis to share their experience in this series of podcasts I host on my blog. See you soon, and thank you for watching.